Hello, everyone. Okay, welcome. My name is Kara Welke. I'm an occupational therapist and the owner of Next Level Occupational Therapy and Home Therapy Solutions, for those of you that do not know me. And I am super excited to have Mike here tonight. So I actually met Mike in Boston. He attended our Next Level Live event in Boston in August. So some of you that are here that were at our event, maybe you were able to talk with Mike at our event. But risk management is a very important topic. We find that a lot of people don't really think much about risk management when they are starting up their practice and running their practice. So I'm super excited for Mike to be here and help educate us all. So Mike, go ahead and take over, and I'll be here if you need anything on the back end.
Okay, great. Thank you so much, Carrie. Yeah, Boston was awesome. Really, really cool experience there. I guess if you haven't had a chance to attend one of the events, it was great. So I will give you just a little introduction about myself because I think it's important to kind of get the frame of reference that I'm coming at this risk management approach for rehab clinicians and here specifically business owners. So the information can obviously vary slightly. I think the information in today's presentation is tailored more toward the business owner aspect, but a lot of this is carryover and the principles are the same. So I'm glad to introduce some of this stuff. So myself, kind of by way of background, I'm a PTA who transitioned to being a PT, went back to school or continued going to school. And then I kind of stumbled, got lucky, got into risk management for a large health system. And very quickly I was in way over my head. So I went and got a degree in almost immediately with how in over my head I was in terms of a knowledge gap for risk management. And I didn't know anything about risk management. I kind of just got lucky. They said you got transferable skills and they gave me a chance. But then I kind of dove in head first. I got a degree in health law, certificate in compliance, and then over time in a certificate in risk management. So from there, I worked in three different health systems, two of which as a clinical risk manager. And then the third job, which was most recently until I took this leap, into small business here, was developing a risk management program for a fairly large health system. I mean, not a large national chain, but a fairly large health system, roughly 5,000 employees, with the goal of implementing a risk management program. And in doing so, procuring the insurance, which is just a fancy word for working with the brokers to make sure we're buying the right policies to insure the health system from the docks to the buildings and kind of everything in between and interacts. And then also as part of that was the claims management. So the medical malpractice claims management of those cases, picking and choosing the attorneys and obtaining and paying the experts and just kind of seeing how that process walked through, which then kind of made me think over time, like all of this risk stuff, you see it in big organizations, but I don't think a lot of small practices really consider it because it doesn't make sense to hire a full-time risk manager. That obviously doesn't make sense. But all of the principles and all of the things that you need to manage on a smaller level for a smaller dose, I felt like are really helpful and even times necessary. So I kind of set out to try to work with small and mid-sized healthcare businesses, specifically in the rehab niche, to try to protect the business with the overall goal of you move a little differently and you can take a little more risks when you know what your potential risk is. So I think it's really important also to know the frame of reference that I'm not an attorney, and I think there is some distinct differences. Although we are working in the medical legal world, a lot of the things that come up in healthcare and especially in healthcare business operations, there isn't a law that tells you you have to do it this way or that way. There's the big overarching laws, privacy and liability and regulatory compliance. And when we're talking about billing, those laws are very specific. And there's, other experts like Kara and Rick who talk about that, which is not what I'm going to get into and is not what I'm an expert on. But looking at your business as a whole, knowing where your risks are, figuring out how you're going to approach those risks, whether you're going to take on risk and go in a direction that might be a new venture, or to do a new initiative, and you're understanding that risk. So I think there is a little bit of a difference. So I'll go through this stuff. I'll go with the objectives. I think we could, if there are opportunities where I'm kind of getting too deep in the weeds, which I'm really not going to do because I trimmed it down. I want you to be able to walk away from this webinar and say, hey, I learned these 2, 3, 4 things that I'm going to remember for a while, and they're relevant for me and they're helpful for me. So I'll hit on those 2, 3, 4 key points so that you've got something you can walk away with and say that this was definitely a useful for your time here. So I'll go over the objectives quickly here. Defining the core principles of healthcare risk management, identifying the most common malpractice and liability claims in rehab. So what can we get sued for, and what are the trends out there? What are the types of things do therapists and therapy business owners get sued for? Defining the legal and ethical components of informed consent. Describing the appropriate procedures for terminating. So you've got a patient in your practice, you no longer want to provide care. How can we go about doing that so that we're not opening ourselves up to risk of liability claims or licensure discipline for our therapists, or even reputational damage, which can be just as big, especially with small and mid-sized practices who operate in a community, whether it's in the homes or brick and mortar. Describing the appropriate procedures for terminating, that one I just covered on. Legal requirements for releasing patient information. So this is another big one when you've got people who are requesting a copy of the documentation, or even just picking up the phone and wanting to know how their mother's doing, things like that. Also understanding the highest risk scenarios by identifying the most common causes of liability and licensure. So what are the 3 or 4 most common things that you should look out for? And then identifying in general the big takeaways for if you own a business or you're looking to own a therapy business, no matter the size, what are some things that you could consider? That's toward the end there. I think, should be helpful. I'm going to go through the next 4 or 5 slides, a general overview of risk management, which I think is important, because when I first got into risk management, I really struggled with how can I message to someone what the heck it is that I do? Because I think we all know therapy worlds are small. You go from working clinically to doing something that even when I got into it, didn't know too much about. You want to be able to have a quick, succinct message that says, hey, this is what I'm doing now. So I'll try to package that up briefly in the next few slides for you so you can kind of have a general idea of what it is. But risk management aims to prevent loss. So we're trying to reduce the incident, or if something has gone wrong, to mitigate worsening of loss. And what does that mean? That means financial, human capital, or reputation. Those are the 3 kind of main areas that I look at in terms of a business. You've got your financial, which is your assets, that we're most of the time talking about liability claims, professional liability. Your therapist or you do something wrong, you get sued, and there's a trickle-down effect. So it could be it increases your premiums because you've had a case. It could be that the time and the worry that it takes you away while you've gotten this subpoena, and now there's in different states it's called something different, but in Massachusetts it's a 60L letter that you file with the intent to sue whatever provider it is. Then we've got the human capital. So if you have a business and you've got employees, or even if it's yourself working in the business, your human capital is your staff. So how can you make sure that the things that you're doing in your business aren't going to lead to you losing your staff, which may be one of the main, likely I would imagine, is the main source of how you're generating revenue. And then the third one, which I think is really important, not often formally taught from the front desk person to the person who leads the organization or the business, is the reputation. A lot of the businesses that we operate rely heavily on a reputation in the community, especially because of the amount of competition there is out there. And at times the margins aren't the highest. So your reputation can really stay with you. And there are a few different things that if you have them in place, you're more likely to be able to protect your reputation. So in risk management, we look at loss prevention, which is observing, reporting, and correcting something that you find that is unsafe. And then you've got loss control, which is after something has happened, how are you collecting the information and making sure that you've got the information necessary in case something were to come up, or to make the next best move in your business, because errors happen, people make mistakes. Poor outcomes are going to come with certain patients. Not everyone is going to be satisfied. And what do you do after that to manage those situations really has a lot of impact on what the overall outcome is. So financial loss, I'll go quickly through this. We're basically talking about money. Most of the time, we're talking about liability claims. When we talk about professional liability, we're talking about the things that your therapist or you are doing within the scope of your practice. So providing patient care, something that you do in that providing care, something goes wrong, somebody files a claim or a licensure action against you, a complaint against toward the board, things that could result in financial loss from professional liability. General liability is things that could happen with property loss, slips, trips, and falls that are not part of the care you're providing. So these are things that are outside of what would be maybe gait training or activities of daily living. So non-patient falls or patients who are not currently under your care that fall on premises. There's a distinction there. Property loss or property damage, things like that. Next, we've got human capital, like we talked about. I mean, these are your people. So in the financial and the people and the reputation, these are your people. So what are the employment-related issues that could come up? It could maybe even something as simple as, which isn't simple really, but there's an allegation and it may be unfounded, but it takes up your time. And how are you going to manage that with the employee? So the risk management may be helpful in the fact that if you've got a really small practice and you work very closely with someone and you don't necessarily want to be the one collecting that information because your relationship with that person may give some bias or it may make it uncomfortable for you. You'd rather have somebody else who's doing that questioning, documenting what's on record so that if 6 months from now, someone's making an allegation against that therapist, you as the business owner can point to the fact that you took the appropriate actions to follow up on the complaint, you took it serious, and you're less likely to be liable for failing to do so if a claim were to come up. And we'll talk a little bit about chaperone policies and where kind of the trends are and how it's impacting liability premiums and insurance. And we'll talk about that. We'll touch on that a little bit later here. And then we got reputational damage. So this can impact the financial and the human capital assets in the long term and in the short term, but the risk really aims to prevent the reputational damage to the clinicians and the business. So we all know the impact of a bad Google review, or somebody takes it to Facebook, or they tell 10 different friends that they had a bad experience with you, and you may not even know that those friends they told could have been patients, or if they're going back to their you're a main referral source to you saying I had a bad experience. I mean, that can really disrupt your referral source, which then I think can really impact your revenue and your growth if one of your main referral sources or streams is impacted because of something that happened in the reputational damage. The strategy in risk is either proactive or reactive. We're either educating staff or we're educating patients, or we're taking the courses and learning all of the things about how we can mitigate the chance of something happening. This would, like, policy is another thing, that if you have a policy in place, then you know how to manage when a situation comes up. And it's very easy to point to, we have a policy for this, we follow this policy. And it takes a little bit of the work out of having to reinvent the wheel of the decision-making process if you do have policy. I don't think you need a million policies. I don't think you need to go into a tremendous detail. I think it's actually a lot of times better to not have policies that are 4 pages long. Oftentimes a 1-page policy that covers what you need to and gives you a little leeway to make decisions within that. A lot of times that's best. And then we got reactive. So reactive is something happened and now you're doing the cleanup of it, making sure you're having the information, making sure you're following up the right people, making sure you're re-educating so that in case it happens again and you want to take an employment action or employment discipline against someone, you've kind of covered your bases in that regard. All of this to say, what does risk management do? I think of 3 things that risk managers do: investigate, consult, and educate. So investigation, just like it sounds, something happened, you're gathering in the information, you're asking the right questions so that you have the right information. Consultation could be things like you want to do a new initiative and you want the perspective of someone sitting alongside you to give you an idea of what the risks might be to engaging in that new adventure. taking on an employee who does something unique, creating a policy in an area where you thought that it might have been a pain point and now you need it. That's kind of all of the consultative work. And then the biggest one is the real-time stuff. So you have something go on, it's happening in real time, and you want to know how you can make the best next move within the legal framework that's going to be least likely to get you in trouble in terms of liability or licensure or reputation. So that real-time consultative piece is sometimes really one of the core functions of risk management, to pick up the phone and say, this just happened. I don't know if we should give this. Let me give you an example. I don't know if we should give this note to this father who we've never seen before. We've been working with the mother. The patient is 19 years old and developmentally disabled, and the father shows up and he wants a copy of the last 4 visits and wants to know when the next 3 visits are, and you're unsure where the father stands in terms of guardianship of this now adult. All of those funky situations. Or we have someone in our waiting room who we think is drunk and they're here with their mother. We don't want them to get in the car. Navigating those tough situations is kind of one of the cornerstones of the risk work that I kind of engaged in, that now has brought me to this realm, and I think is helpful. At least that's what they say. And then the education, so the proactive stuff. So things like this, but even getting into more detail in certain areas, whether it be informed consent or treatment of minors, or releasing information, or having chaperones, or even mandated reporting of elders, developmentally disabled, or children. So things like that. But that's what we do: investigate, consult, and educate. I kind of went into the details of this. I think I pretty much covered all the different aspects of that. So we'll move through that. And then here's a big, this is a big area that I think if I had known, I was talking to somebody earlier today and they're like, what is something that you think would have been helpful had you known earlier? And I think this stuff right here, because I think you just move a little different. You operate a little differently if you know that the case that you're encountering with the patient is not something that you're likely to get sued for. Because as therapists, we have this kind of, at least I did, this overall feeling that if something goes wrong or if someone's upset, I may lose my license. And there are some things you should worry about, and there's a lot of things that you shouldn't. And if you're not wasting your time worrying about it or dealing with it, then you're more likely to be able to be spending the time where you'd like, which is caring for your patients and growing your business and making money and satisfying those in your community or whatever it may be. So in terms of professional liability and medical malpractice cases, in order for a case to move forward to a liability claim and a lawsuit, you pretty much need these 4 things. I mean, really, in the vast majority of cases, this is how it's looked at for a case to move forward: the duty, the breach, the damages or harm. I'm going to refer to it as harm often, and causation. So duty, breach, damages, and causation. This tends to be a key point that a lot of people are interested in knowing. So this will be one of the takeaways. I'll get into a little bit more detail here. So what is the duty? The duty just says you're the therapist and this is your patient, and you've now started a relationship. From that point on, you have a duty to provide the standard of care. The standard of care is not exceptional, A1, board certified and everything level of care. It's not making that diagnosis on your initial evaluation of a very rare condition, because this will come up, at some point, maybe not, but where someone says, hey, I saw you for 5 visits or 2 visits and I went somewhere else and they figured out what was wrong with me and you didn't, and it was an error. It's important to note that your obligation is to provide the standard of care with each encounter, not to provide A+ exceptional level, miraculous Dr. House stuff. You have to provide the standard of care. That's your duty. Your duty is the patient has come, they've seen you, you've made an evaluation, you've made an assessment. Now they're yours and you own that encounter. Each encounter should be looked at individually. Next is a breach. So what is a breach? It just means that you didn't provide the standard of care. So again, we're talking about what aspects do you need for somebody to have a medical malpractice claim against you? It's the duty, just that they're your patient and you're obligated to treat them because you've created the relationship. And then the breach, which is you did something, you failed to provide treatment that meets professional standards. So In the rehab setting, we're talking about performing contraindicated interventions. Example would be dry needling neurothorax without proper precautions, ignoring red flags like new onset neurological symptoms. This could be, as simple as patient has, the worst headache of their life and you don't check their blood pressure and their blood pressure is through the roof, or you do check their blood pressure and it's through the roof and you continue on with putting them on the treadmill. Inadequate supervision of assistants. This one does tend to come up fairly frequently. And then poor documentation that fails to justify care. So poor documentation on its own can be a breach of the standard of care. So that's another takeaway. Poor, limited, or inadequate documentation can be a breach of the duty. The third of the four that you need, and this is the biggest one, is damages or harm. So if you're going to take away something from this presentation and you've got cases out there and someone says, I'm going to sue you, or you think, you heard from so-and-so that the patient is really upset and they're going to sue you. If there is no harm to the patient, most of the time we're talking about physical harm, then your level of concern should go way down. So the difference between a liability claim or a criminal act is the difference between the bullet hitting the person. So if we think about it like it's a bullet, harm would be you did something wrong to your patient, you pulled the trigger and you missed them. Yes, you made the error by shooting that gun off in their direction, but if it doesn't hit them, if there is no harm, then you're essentially not likely to have a malpractice claim. So errors happen, but if there's no harm, your level of concern should go way down. Most of the time, like I talked about, we're talking about physical injury. So examples would be a fall during gait training, that would be harm. A burn from hot pack, the burn is the harm. Nerve injury from modalities, the injury is the harm. Or a pneumothorax, a punctured lung from dry needling, the harm exists there. A delayed recovery or worsening condition, or emotional or financial harm. And really, a lot of times with that stuff, you got to prove it. So what would the emotional harm be? If they went to a therapist for 3-4 visits after because of the mistake that you made, that could be considered as harm. And then the last and final piece, which oftentimes the other three may be there, but the causation isn't. So you've got a patient, it is your patient, which is your duty. You did make a mistake, meaning that you breached whatever the standard of care was. You did a contraindicated modality. There is harm to the patient, pain, suffering, whatever that physical harm, injury, damage to the tissue, but you don't have the causation. The causation is just that tying what you did, the mistake that you made, to the harm. So the causation is the bridge that gets you the opportunity for a malpractice claim to exist or advance against you. If there's any questions on that, you can raise a hand. I'm happy to go into further detail about that. But those are the four components. Now, common malpractice claims for therapists, which are different than surgeons and different than dermatologists and different than primary care docs. Patient injury during therapy is one of them. So harm caused during therapy due to alleged negligence or unsafe practices. Common examples of this would be a fall during gait or balance exercises, improper manual therapy or joint mobilization, which caused harm, complications from dry needling. And then what do we think about in terms of risk management? Follow the standard of care, the safety protocols. If you're seeing a post-operative patient, make sure that you're following those doctor's orders of the post-operative protocol. Week 2 says do this with the shoulder after a rotator cuff repair, whatever it may be. Make sure that you've got a process in place and that your therapists are following those protocols, because that's an easy one for plaintiff's attorneys to pick up on there. Ensure supervision and patient education, and then document the assessment and interventions thoroughly. Clinical reasoning, documenting your clinical reasoning. If you're going to document anything, or your therapist is going to document anything, I think oftentimes the most important part of that documentation in that encounter, whether it be the treatment session or the evaluation where you're determining what's going to go in the plan of care, is the reasoning for it. I can't tell you how many times that a therapist or another medical provider made a decision that may have been the right decision for the encounter, but the documentation doesn't show why they made that decision. So then it leaves speculation as to Why did they make that decision? Even if the outcome wasn't controllable by the therapist, if you don't have the reason why you did what you did, it becomes a lot more difficult to defend if a claim were to arise. Another common malpractice claim for therapists is the failure to recognize red flags. So not identifying the contraindications or the emerging medical conditions or the need for referral. This is another big one. I think, things happen to patients after they leave our care. We want to be able to demonstrate that in the time that we had them, we identified certain things or didn't identify certain things about them, and then we made assessments and recommendations based on that. So if you have a patient who has a gross change in condition, whether it be neurologic or cardiac, and you note that in your note, but then you don't take the next step to educate them on what they should do, offer them a recommendation, make communication to a referring provider, or make communication to a family member if if the patient doesn't have capacity or they're elderly and they've noted that they want their daughter to be involved. Make that next step after you've identified what the issue is. This is a really big one, a key takeaway. Very important if you own the business to be educating your staff on the importance of recognizing the red flags and then making the next best step in terms of a handoff or a recommendation or an education. Another one is informed consent. So I think, there's you guys can kind of read the slides here, but I think the biggest takeaway message with this one is know that informed consent is not a document. It is a process, and you are held to the fact that it's a process. You're signing a written consent acknowledging that you've gone through the process with a patient to identify the risks, the benefits, the alternatives, ideally the likely outcomes that a patient could anticipate when you're recommending a certain aspect of their care. But it's very important for the business owner and the therapist to know that the informed consent is not a document solely. It shouldn't be something that if you're going to do a new treatment on someone, you're going to do cervical manipulation, you're going to do dry needling for the first time and a patient is nervous, or you're going to do, I'm sure you guys can probably come up with the interventions better than me, but if you're going to be doing something that increases the patient's risk profile, you're having the informed consent conversation that fully outlines them for that. I guess by way of an example, I dealt with several cases that were surgery cases, very accomplished surgeons. I had a neurosurgeon who did a lumbar spine surgery on a patient. The informed consent was signed. There was really no issue with that. It was signed preoperatively. We had a copy of it signed, but the patient was adamant that he was not told the intricacies and that he was going to get the hardware in that location and that it wasn't going to be removable. And he had all of these aspects that 9 months later, after he had had the surgery, he had some lingering pain, but no gross issues. He was talking to a friend who had the same procedure. That friend had this procedure done by another doc, knew more about the procedure, and the patient was incredibly inflamed with the fact that he wasn't told X, Y, and Z, the hardware, how it was going to be, where it was going to be, that it couldn't be removed, that his partial disc was going to be removed. He was so upset that this took hours and hours of negotiation with the patient just so that he was okay in terms of his mental state. So even if it isn't going to turn into a malpractice claim, the reputational and time impact that it has in navigating and managing this isn't worth it. So encourage the staff to be having these conversations. And if the takeaway would be, if the risk changes based on what you're doing for them with that new intervention, you probably should at the very least be having conversations about what your expected outcomes are. If it's going to change the risk profile significantly, it should be documented and signed off on. A lot of these things I don't want to make more work in an already laborious sector of therapy with documentation and forms and things like that. So I think the biggest takeaway is have the informed consent be a process, not just a document. These were the 4 aspects of medical malpractice. Just again, duty, breach, damages, and causation. For damages, we're going to call that harm. And harm is where risk management oftentimes begins. So if you're in the if you're in the kind of the world of quality or patient safety or patient experience, and they're talking about cases, really it's the risk management ears perk up when we talk about harm, because we know that with harm, we have likelihood of a claim. Without the harm, the interest is more in managing the reputation or the experience, not necessarily the liability or chance for financial loss or licensure loss. Common high-risk topics, any one of these really on their own could go for a full presentation. I think it's important to just know that these are kind of the big risk topics in general, especially if you're a business owner. You may want to have a little bit of an understanding about these areas. You don't need to be an expert in them, but you should have an idea that they exist and that they are common risk topics. Informed consent, like we talked about. Healthcare decisions, what that means is, in short, is that people have the autonomy to make a decision so long that they have the capacity to do so. So it is understood that an adult who is not developmentally disabled hasn't been determined by a judge that they are under a guardianship of someone else, they can make their own decisions. I think as healthcare providers, we need to keep that in mind, that a patient has the right to make a bad decision. You have the obligation to make a recommendation that's within the standard, and you have a recommendation to educate and offer that to them. But what they do with that is up to them, and we need to respect their autonomy on that. Other things are releasing information, mandated reporting, terminating a patient or client relationship, which has come up a lot in recent years. Sensitive exams, which is the biggest hot topic when we're talking about getting insurance for your business, because the insurance industry doesn't exactly know how to handle whether this is going to be covered in policies and to what extent. And especially if you have a pelvic health business or you do sensitive exams of any sort, breast, genitals, anus, if you're doing any treatment in and around those areas, then you're going to want to at least explore the option of having a simple chaperone policy in play, because it may impact when you go to shop for your liability insurance, your professional liability. It may have impact. I think there's a ton of work being done on that right now, and there's kind of a jockeying for position of which major medical malpractice carriers are going to cover that in policies or they're not, and you're going to have to deal with that on your own or purchase a policy above and beyond that. We've got falls. Falls is obviously always a big one. And then managing patient complaints and adverse events. I really think that's something that can be taught to everybody in the business, especially those at the front desk who might not be providing care, but they're encountering patients on a daily basis, and they may be most likely to learn of a disgruntled patient or disgruntled patient's family member as they sit in the waiting room or you have conversations with them over the phone. So let me go back here. Boom, boom. Elements of informed consent. I kind of touched on these, here they are in terms of graphic form for you, but the patient has to have capacity, and that goes into healthcare decision making. The providers disclose of information necessary to make a decision, so making sure you're giving them all the information. The healthcare provider judgment that the patient understands the information. So you should be assessing when you're talking to your patient, if they feel like they're not getting any of that and you're about to move forward with something, you may want to have a pause and explore a little bit more about their condition or their level of capacity. We as therapists don't make a decision of whether or not a patient can make their own decision. That's done by an attending physician, oftentimes a primary care physician, and this is different state to state. But for instance, in Massachusetts, it's a healthcare proxy document that will be invoked. In other states, it's medical power of attorney. It depends on the state that you're in, but you really want to know who's got the ability to make the healthcare decision for the patient. And then the patient or surrogate freely authorizes the treatment plan and with a signature. So your general consents when you're seeing a patient. A lot of times they're going to cover that. I touched on healthcare decisions, informed consent. We talked about the different aspects. One of the key components I think that's important for the rehab space, and I know that, I've been to different conferences where they say, plaintiffs' attorneys have kind of honed in on, are you offering an alternative? So you might recommend something for a patient. If they have pause about it and they're somewhat unsure of whether or not they want to do that, you should offer an alternative. Even if you don't think it's the best thing, you should offer it. State what your, what their condition is, what your recommendation is, and say, hey, this is what I think we should do. If you don't want to do that, that's fine, and we'll do this, but you should offer that. Especially if there's something that's, slightly more invasive. Dry needling might be a good example of that. The benefits of informed consent. So patient-centered care, increased trust, enhancing the relationship. You're setting the expectation. You're closing the loop on the follow-up, and patients are more satisfied and you've got less claims. The challenge is basic information on the consent form. So do you have the alternatives? Is the communication effective? Is the patient speak a different language primarily? So these are some challenges that you may run into. Now we have releasing information. So in patient care, when there's a breach of privacy, it can really harm the therapeutic relationship. Miscommunication of information can result in clinical errors or delayed care. And then you've got kind of the legal or financial impacts. That's really falls in the risk wheelhouse, but the fines are significant. So especially if you're a small practice and there's somebody who incurs harm related to the fact that you've released information. So if we've released information about a patient to the wrong person, but the patient doesn't really seem to care and nothing comes from it, you may have some reporting obligations, regulatory reporting obligations. But if there's no harm that comes from your release of information, you likely aren't going to have a claim that arises. But there is a way that you should manage. Hey, you sent out an email to someone, you CC'd a couple of the other patients on this by mistake. Now they know that your patient, John Smith, has, hip tendinopathy. They have that information. They're now out in the community. Who knows? Maybe they work together. It gets the waters get really muddy. So if that happens and you have a breach of HIPAA, you shouldn't ignore it, especially because the harm may come up later and it's going to point back to you whether or not you stopped the breach, you investigated the breach, you notified the individuals. And then if it's less than 500 people at the end of the year, within 60 days, you notified the regulatory body that, hey, this breach happened and this is what we found, and you're documenting that. Having a simple policy on how you're going to manage if someone asks for information, how are you deciding if they're going to get it, and then logging that you've given it is the best practice. It might not be super reasonable for some smaller practices, and I think we need to look at what's most reasonable in terms of handling those. If they're looking for a one-off note and it's the patient's wife, low risk stuff. Ideally, it's best practice to have a process, especially if you're having some of the front office staff do some of these activities of releasing information. You're going to want to have a policy in place that you as the business owner have an idea and an expectation for those who are actually giving out the information. You don't just want someone shows up, front desk gives them a copy of the last 10 notes, or they request, you got a fax from their employer and you send it off. You want to be very careful about that stuff, especially the employment related requests for information or requests for information that come from attorneys, because sometimes there are other ongoing claims that may involve workers' comp or other cases that are completely unrelated to what you're seeing the patient for, but they're requesting to get information. That can be extremely problematic, because if your patient suffers some harm related to your improper release of that information, it's fairly likely that you're going to see something by way of a claim related to that. So having even if it's just very simple and minimal, an idea of your process for releasing that information. Then we've got mandated reporting. So mandated reporting is abuse and neglect. These are big ticket items, but most, I think all states, but you want to check with your state, but I think all states you're obligated as a physical therapist, occupational therapist, or speech therapist to report if you have a reasonable suspicion of abuse or neglect. And then each state, a lot of states have different contracted agencies who will handle the receipt of that report and then go through the investigatory process. And a lot of times you're giving them information and they are privy to that under the law. Terminating a patient or client relationship. This is a big one. The big takeaway here is if you terminate a patient who's in the middle of care and you can no longer see them and they can't get to care fast enough. A good example of this would be you've got a post-operative patient. Their behavior is not in line with you being able to continue to treat them therapeutically, and you want to terminate them, but they can't get started for another 2 weeks. And then they have this because of the rural area they live in, or whatever it may be, it doesn't really matter. If they have a gap in their care and they have harm that comes to them from that gap in their care, you could be on the hook for a claim of therapist abandonment. They call it abandonment of the patient-provider relationship. So these claims do exist. It is if you're looking to reduce your risk of this, because I don't think we should have to treat everybody who spits in our face or steps on our toe or says they're going to kill us. I think, and I dealt with this in the health systems all the time. We've got patients who just don't line up. You want to be able to point to the fact that it's not a therapeutic relationship. You want to be able to try to give them a warm handoff to some other provider in the area who they might do better with. You want to facilitate getting their notes or medical records to whoever they feel like they want to go see, or they're signed up to go see. And then if it's somebody who's really in the middle of their care and it may incur harm, you want to think very carefully about those cases, because you wouldn't want them to say, I need a manipulation under anesthesia because I couldn't have therapy for 2 weeks because you terminated me with no notice because I told you, I didn't like your hair. So you want to just, handle those situations with care. Sensitive exams, if you're doing this, is really speaks most specifically to pelvic health. There could be other things that you're doing, but you may want to consider having a chaperone policy for more than the fact that you're protecting your business and your therapist from an allegation. Because what can happen is these allegations are very damaging. There are bad actors out there, so there is the patient protection aspect of this. But if you really want to be protecting your therapist, you've got a policy in place that allows them, if they're not comfortable, to have a witness in the room while they do that sensitive examination. So I think it's important for patients to feel like they can have somebody else here if they're uncomfortable. They may have a traumatic history. There's a lot of, different things that we might not, initially know, but that will come into play. Having a simple chaperone policy, and this doesn't mean that you have to have somebody in the room with you for every visit, because I do understand that operationally that is not possible. But I think you want to have something that allows you flexibility to be able to, hey, take a pause or reschedule if your therapist is uncomfortable moving forward in that examination. This is just more about sensitive exams. One of the biggest things about this is that without one of these, I think it's simple to have in place. You want to tailor it so that it meets your business. But without this, it may have significant impact when you go, back to your broker or to secure your insurance or renew your insurance for the year. At some point in time, there's going to be a big shift in how these things are managed. You're going to want to know what is covered under your policy, what's not covered under your policy. And one of the simplest ways to at least mitigate the increased cost or the coverage is to have a chaperone policy in place. I can tell you from experience that when we were renewing our professional liability insurance in the health system that I worked at, these carriers did a lot of due diligence to see what was in place. And it may not be that they won't not cover you, but you may have less options. And if you have less options for the carriers that are going to insure your business, less options means higher price for you because there's not as much competition. And I think this is kind of something that isn't a giant lift, but you should have tailored to your practice. Falls, documenting, where are we at? Falls, documenting post-fall. So just some key points, but after you have a fall, you should consider making sure that you've gone through and documented certain things. The worst thing that can happen is you have a fall and the patient is fine, but the patient goes home, falls again, and then they get injured and they go off to the hospital and they can't discern whether or not that fall was when they fell at home or when that fall was when they fell in the clinic, because you didn't do a thorough assessment and document it. Very simply, get a good idea of what happens to that patient after they fall. Even something as simple as what they said after, or what their symptoms were, or what their range of motion looked like, or that they were able to walk off no problem and get in their car, or that you communicated with others. their wife if they weren't present, or whatever it may be. I think that's something that's very important to have. Next, we've got managing complaints and adverse events. You can't talk your way out of a complaint. I think the most important takeaways here are you should be listening. The patient who's going to be most inflamed and who's going to go to Facebook and go to the board and go to the Google review is going to be the patient who doesn't feel like they're heard. I can tell you this from firsthand experience, like managing cases in health systems when things went really wrong. If you contact the patient and you give them an opportunity to fully state exactly what it is that they are most upset about, and you listen to the entirety of it, and you tell them that you'll look into it, you'll review it, you'll get back to them, and then if you do that and there's opportunities for you to improve, you let them know, it's really going to have a strong impact on any damage that could come to your reputation. Staff training, again, I think it's really important to have everybody in the practice, whoever's encountering patients, to know exactly how you're going to go about managing your complaints and adverse events, so that everybody knows, okay, so-and-so called with the complaint, they left a voicemail on us after hours, we're going to call them up, we're going to listen, we're going to tell them we'll investigate. And the investigation might be simple. It might be as simple as reading the notes and talking to the therapist. And this is kind of, gets more into the risk management activities if there is harm related to the case. But just an opportunity to hear what they said, follow up and get back with them. And you don't have to tell them that you're going to change everything or you're going to fire the therapist. A lot of times, just the simple fact that they were heard is going to prevent them from going other places. This slide kind of goes along, with the same ideas: acknowledging the incident, communicating a plan, and offering an explanation or follow-up. And then just don't overpromise. Don't say, hey, we're going to do X, Y, and Z. We're going to make this giant change. We're going to fire this person. Don't jump to a solution for something until you've really had the entirety of the case looked at. Common licensure discipline for rehab therapists. So we've got, negligence or substandard care. That kind of speaks for itself there. Improper treatment. You do the wrong thing for the condition that you're treating. It's pretty standard. Impairment or substance abuse. This can be challenging for a business owner because you've got somebody, patient made a complaint, or another therapist is saying, hey, I think Billy looks like he, having a rough day here. How do you approach that? I think oftentimes you want to make sure that you're having the conversations, asking the right questions, and then documenting that you've had the conversation. Because if you're the business owner, a lot of times it's going to come down to, if you were aware, did you do due diligence? So keep that in mind. If you own the business, you're on the hook for the point at which you became aware that you took some action there. Boundary violations or sexual misconduct. We talked about chaperone policies to help, mitigate the patient interactions. But then again, if we have, between staff and staff, that's where it's really helpful to kind of have a third party do, a conversation. If you're the business owner and you're comfortable with that, or you're in a small practice, then, having those conversations, collecting the information and writing it down. That's kind of the simple takeaways there. Fraudulent billing, this stuff kind of speaks for itself. But if you're regularly auditing billing practices, it's helpful. Again, back to the overall thought that if you become made aware, you've got obligation to take action. Not necessarily immediately, but you've got an obligation to start the process of taking action. So what are the big takeaways for the business owners? Risk financing. You can either avoid, transfer, or retain the risk. And it's pretty simple. In most practices, you should have a professional liability, your scope of practice stuff, in case you get sued there. You've got your general liability, especially if you own the building, or even if you're going into homes, you may want to explore what general liability coverage would look like for like property damage and things like that. And then cyber, depending on how big your practice is and where your information is going, if it's going into a cloud with a third-party vendor, you make sure you want to look at those policies, because they may or may not have coverage. That third party may put all of the risk onto you, and you don't need to be an expert on that. It's just, sometimes it's what, risk management can help you walk through that process of asking your broker or the vendor the right questions. And it may even be just a, half an hour or an hour conversation you're having with them. But like I said, you can even retain risk. If you're like, that's not worth the policy, I don't think we're going to get into issues with that, I'll just take my chances with that. I don't think it's a big issue. We don't do enough of that. You're retaining the risk. You're saying, you know what? I don't need to buy insurance and I don't need to avoid doing it. We're going to move forward. I think it's healthy to take risks. I think I've got 4 kids and left a pretty good job. So I'm definitely not risk averse to go into, into this adventure that I'm doing here. So I think the takeaway there is it's healthy to take risks. And I think a lot of the businesses that do well often end up taking risks. And then trending internal policies. So overall, what policies should you consider if you've got a small practice, or even, you've got 5 to 10 practices? If you're doing pelvic floor, pelvic health, women's health, consider a chaperone policy. Allegations of misconduct, just so that you have a little process. I don't think you need 5 pages of this stuff. You just need something simple. A patient complaint or grievance, requests for information, and then the employee use of AI and social media, even if it's as simple as, hey, we don't put our patient data into Chat GPT when you're trying to figure out their diagnosis, because you as the business owner can be held to the standard that and you've clearly outlined what you and your staff are doing with protected health information. So I think that one may be important, so then they're not, posting pictures with their patient on Instagram and things like that. And then this is kind of just more in general about what risk management does and what can do for the business. I think some of the big things that might be worth mentioning is having risk management might reduce your insurance premium because they see you as less risky because you've got a fractional risk manager. And then I look at it differently than your local attorney, who's probably going to help you draw up a contract, or if you actually do get sued or you get subpoenaed where you have to testify, you want to reach out to, you want to hire and secure an attorney. But a lot of this stuff in the in-between is really more risk stuff. And I learned that working in a legal department in my last job. But it's basically a confidential partner who can walk you through the process on a lot of these things. And oftentimes people don't want to call their insurance company and they don't want to call their attorney. At the last job I was at, they felt like, the attorney was billing him on the hour and was going to end up, making something longer than it needed to be. I used to work with outside counsel on different things and, reach out so that they could dig into the courts and see what the latest court documents were. And I found myself on a 45-minute call that could have been 5 minutes. And it took me a year to realize, oh, maybe the bill per 15 minutes was the reason why. Not that attorneys aren't great, they are. And they're needed on a lot of these different things. But the other thing is, you might not want to reach out to your insurance carrier or broker to tell them all your dirty laundry. When you have a risk manager, they work for you. You make the decisions. When I work with businesses and in organizations, the docs and the business owners, you make the decisions. I just provide you a recommendation from the risk management perspective. Questions, cases? I know we do have one question that came up that we got in email. I don't know if we want to maybe start with that one, and we'll go with other questions first. Do we have any thoughts? What do you think, Kara?
Well, let's start with, does anyone online that's with us tonight have a question for Mike that you want to ask? You can type it out either in the chat or in the Q&A spot, and we'll go ahead and go over that. For those of you in the Therapy Business Builder program, Mike is coming back to meet with us more one-on-one in next week, I believe. Is that right, Mike?
I think so.
Where we'll dive in a little deeper on these things and so forth. So just a heads up on that. But for those of you that are online, feel free to ask any questions. And Mike, maybe we can go over with the one that was emailed in.
Yeah, let's do that. So the question had to do with, and I think this, normally we would have a little more detail. It was a great question though. I think it's a practice in Louisiana. And the question had to do with, we've got video surveillance. I don't know if they said surveillance, but we've got video cameras in the clinic and in the parking lot. Do we need to have a policy on that? Or I think the question was, do we need to have consent in order to be recording? And the big takeaways from this are how you treat your security cameras or surveillance cameras or treatment cameras, whatever the purpose are, it matters, but the inside is much different than the outside. So the outside is more security, surveillance, and might be helpful if someone says they tripped on your property and broke their leg, and then you look and you see they didn't trip on your property, but they're suing you for a general liability claim, or police show up and they want to know, where's that car that just left the practice, or somebody hit my car in the parking lot. Sometimes the cameras that go in the lot can be a little bit more of a headache for you, because then you've got this footage and now you've got to be, subject to these investigations, and not, how long are you going to retain it? I think in this case, they said they were retaining it for 30 days, which to me seems reasonable. But really where you want to consider having a policy and a consent is if you're filming people who are getting treatment in your clinic, because I think in the state of Louisiana, I looked it up earlier, it's a one-party consent. So you only need the permission of one person. So you don't need the other person's permission to record them. If it's audio, if it's video, you do. So each state is different. For example, Massachusetts is two-party consent. You can't record someone on audio without their permission. So you have to check and see it's a very simple Google that says, is my state one party or two party consent for recording? But to answer the question, you should absolutely be getting a written consent, especially if you're retaining the footage of individuals who are receiving treatment in your clinic. It's probably best practice to have a little sign up for the outside that says, video surveillance underway, but your obligations are not the same because you can't tie PHI to it. But you should have a simple form that's signed that says, hey, we've got recording in our treatment rooms or in our waiting room. If you agree to have treatment here, you agree that, we're going to record this for, and whatever the uses are, clinical use or safety use, whatever it is, and have them sign it. It shouldn't be a huge lift, but I think you should have a form there.
Awesome. Okay, we have a couple other questions in the chat. Do you want to
Yeah,
just read them and
rifle through them here. Yeah, let's see. I want to. Sorry, I missed the first half. Is there a template available for a risk management plan similar to your P&P manual? Is P&P your manual, Kara?
yeah, so we do have a compliance plan that goes over a lot of these items, as well as there are policies and procedures in our policy and procedure manual that cover most of these items as well. But Mike, I can show you both of those when we meet, and we can discuss if there's anything else, but should pretty much cover most everything between our compliance
cool.
plan and this.
Cool.
Also the recording, we will be sending out the recording, so you guys do have access to the recording, after the fact. Those in our therapy business builder will be uploading it, everything into your courses too, so. Is this also important for a 1 to 2 practice cash, or mostly for insurance-based practice?
Most of this stuff is the same, whether you're doing cash or insurance. I mean, really, the liability doesn't change. The scope of practice doesn't change. What comes into, managing, poor outcomes, terminating a patient. I don't think there's anything real. The only thing that may be a tad different is when you're terminating a patient. If you have an insurance obligation, if you're under contract with a payer, you may not, in some cases, be able to terminate a patient the same way you would if you were cash based. So that's the only thing I can really think of off the top of my head.
And I will say that this is a common question we see out there. And we see that a lot of people, think that if they are private pay and so forth, that they significantly reduce their risk. But again, you still have a healthcare practice. You still have to follow our rules and regulations and everything with that. So,
Yeah, and I think
Carrie,
go ahead. Yeah, yeah.
oh, no, I was just gonna say, Carrie said, if a spouse says they are the medical POA, are we obligated to obtain the paperwork showing this?
I mean, this is one of those things where, like, the risk and the legal and the the attorney answer might be a little bit different. And it depends on the state, because some states say that if it's reasonable and that that, based on other information. So you can decrease your risk if you know that this is a patient who wants the wife to be involved and has been involved throughout the whole course of it, and there's nobody coming forward to object, then it's probably fine. But if the patient has pause or concern or doesn't want the wife to know, or there's a third party that's coming forward saying no, that's where you want to request that you get something in writing that says, hey, I'm the decision maker for, it's probably standard paperwork in the state that says, medical power of attorney has been granted to so and so for patient so and so. So the best practice answer would be ask them for something in writing. That's why it's uncomfortable if you don't have a policy that says, hey, this is what we require for everyone, because then you could just point to it and say, hey, this is our policy. But it's if you know this person and it's low level and they don't seem to be maligned with the patient, it's probably not a big risk. But I would say the risk recommendation is the best practice is to ask them for proof if they're going to be making healthcare decisions for that patient.
Awesome. This is a good question. We have a couple others. What best practice to document informed consent when administering cognitive assessments?
Okay, yeah. So this is a great question, and the big difference here is that you're assessing their cognition for treatment, but not to make a determination about their capacity, right? So they might come to you and they've got an adult who's got capacity, or you have no reason to believe that they can't. So if you're getting a written consent and this is an adult and you have no other reason to believe that they don't have their mental capacity, then let them sign it. And then you're thinking, well, geez, what if I then do a cognitive assessment that shows that they don't have capacity? I think that you're then making communication to whoever's most appropriate. So if they want to come in and consent for treatment and you find out later after they've consented to treatment that they don't have that they're not putting the dots together here, then really the toughest question is what's your next move? But okay for them to, sign the consent form if you don't have any other reason to believe that they don't have capacity to make a healthcare decision. But there's
How
probably
about
more
if
nuance to
you,
that.
how about if you're actually doing a cognitive assessment, they have a diagnosis of dementia, but you're doing an assessment to determine what stage they're at and if they've had a decline or improvement, what would you do then?
And are they already your patient?
Yep.
Okay.
Well, no, let's say no, because let's say you got a referral from a physician for someone that has dementia, but they want you to do an assessment to determine what level they're at.
Okay, so if they walk into my clinic and if they're driving, then that's going to tip me off to the fact that they probably haven't been determined to not have capacity. My risk goes down, it might not feel great, but my risk goes down if they drive into the clinic and they've got a referral from a provider for the patient and they show up alone. If they show up with a person, I simply ask them, hey, can I talk to your wife? Should I talk to your wife? If they become combative and they want to make their own decisions, then I still think that you have to basically, the patient has the autonomy to make a decision if they have capacity. If your findings indicate that they don't, you want to make communication back to an individual who can determine legally that they don't have capacity. So should you document, you're not going to get in trouble if you've documented that, patient agreeable to move forward with cognitive assessment.
How about if
Give me a
you're going
give
to
me
see
like
them in the home? Because I know a lot of therapists that are even on here tonight go to see a client in the home. So they might be going into a home and this person is the only one there and they have dementia and so forth. Any thoughts on that? I'm just giving
I
you a
think
lot of
on the
scenarios.
refer No, this is perfect. This is perfect. These are the questions. So I think you need to be, I think in most of these cases, you should be able to be in conversation with somebody else. So if I'm going out to see a patient, I know they've got a dementia or advanced dementia diagnosis. I'm looking to see who are the other contacts on there. And I think it's very low risk to reach out to that other contact because you can point to the fact that this patient doesn't have cognitive ability to really guide me in this process. So I would go out there, engage the patient, see where they stand on it. And the only reason I wouldn't reach out to someone to move forward with it would be if the patient is absolutely adamant against it. But I think you're going to have to do more investigation into this one, right? So like, yeah, like patient has the big question here is, can I get in trouble if I do this assessment on someone and it says they don't have cognition, but I took their consent to do it? If the patient is agreeable, you've got a lot less risk. I mean, the practical thought about that, like who's gonna contest that you did a cognitive assessment? Normally it's gonna be the patients that contest this. So if they've already, I think it's very low risk. It's okay. I would think it's okay. Go in there, see the patient. If patient's agreeable, do the assessment. You could say patient, I would say patient agrees, and then note that you're communicating with whoever else is listed as a contact.
Awesome. And then, so a lot of therapists are using scribes now. So Nina has a great question. She says, when my patient has given me permission to use a scribe and then another person, family member is present for a visit, do I have to get the family member's explicit permission? And she is in California.
Okay. I would I would simply ask them, say, listen, we're using an AI scribe. I would just have that conversation with them and I would document, we're using, I don't know exactly how you normally document the use of scribes, but normally, you're checking off a box that says patient agreeable to use of scribe, something to that extent, right? I would get the family's permission but you're not recording it. You're just using scribe, but I would have the conversation. I would document it in the chart, but do you need to have them sign a written form? No, I don't. I'd have to look and see what the privacy laws specific to California are. Just in general, takeaway is if the state law is more restrictive than the federal law of HIPAA, you have to follow the state law. So you'd want to see if California was more restrictive than HIPAA. But in this case, I don't think you need to get written consent. I think it's more of a best practice case where you would say, patient's daughter is here, patient is agreeable to daughter's presence, daughter is agreeable to use of scribe.
Awesome. Okay, those were all of the questions. Any other last minute one? I know we're over and time, and I want to be cognizant of your time, Mike, so I appreciate that. But if there's any last minute questions that anyone else wants to ask, let us know. Doesn't look like it. So follow up will, for those that attended, you will get the recording so you can refer back to that if you have additional questions. TBB crew will get it uploaded into the courses so you have access to that as well. So thank you, Mike. Greatly appreciate you coming in and look forward to breaking things down a little bit more next week with you. So everyone
Cool.
have a great night and we'll talk to you all soon.
Thanks for having me.
Thank
See you
you.
guys.
Bye-bye.